I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what the day is. But it's exactly what you make it. So please don't go wasting. And I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. What a good day is.
All right, y'all know what to do. Good morning. Good morning. Hopefully everybody's doing well. Y'all drop a 1 in the chat for me if you can hear me. Drop a 1 in the chat if you can see me. We about to go ahead and get into it. Oh, I can't believe it. We're back, y'all. We are back in the building. Hopefully everybody's doing well. Let me see how we looking up in here. We should be good. Ooh-wee. Looking all crispy and clean on the screen. Hopefully y'all are doing well. Welcome back, everyone. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, ClassE Beats of ClassEbeats.com, and we are going to go ahead and get right into court proceedings. We've got a lot going on today. Judge Whitaker is back and is going to be hearing from all the remaining YSL defendants. We've got Yak Gotti. He's got a bond hearing today. We've got Shannon Stillwell. He's got a plea deal going on. Woo! What is going on, man? A lot happening. So we're going to try and balance everything out and make sure we don't miss a moment. But first, let me say what's up to the people in the building. Of course, shout out to my awesome, amazing Amy in here. First thing, showing love. Appreciate you, Amy. Reminding y'all to like the video. Shout out to Amy. Les Cleaver in here. We've got Mona Lisa is in. All right, Stuck Farmer, Susan, Drama Llama, A Fifth, Lavisa, Kim, Leona, John, my guy, salute and thank you for your service, sir. We've got Christina, Jay Buckmaster's in the building. Young Dreads, I see you. We got Gerald, Valencia, Gwen, Angela, Dennis. Oh my gosh, everybody's up in here. I'll be saying good morning to several of y'all as we go throughout the show. And shout out to my dog Rice Street with the light number 36. If y'all could, please make sure you like the video on your way in. Not only is it free, not only does it help the show continue to grow, but it lets the YouTube algorithm know that y'all are enjoying the show and it shares the video with more people. So we are waiting on a couple of things to start the morning off. We still haven't got it started with Yak Gotti's bond hearing yet, so we're still waiting on that. Judge Whitaker hasn't started court proceedings with her, the remaining YSL defendants, and we're still waiting to hear what's going on with Shannon Stillwell because he's supposed to have started shortly too. So we'll get into that in a second. What I'm going to do is we're going to go ahead and switch right over to the court proceedings for Yak Gotti's bond hearing. All right, here we go. And not too much happening here yet. We actually have a little bit of delay. I know Max Sharp stopped by the courtroom. This was a funny moment. Max isn't even involved in this case, but he's just stopping by. That's of course Yak Gotti's mom right there.
Do you have one of the? You're just a hanger on. That's what I thought. Okay. You got
Max
nothing to do
says
these days.
he's just hanging
No,
out.
I'm actually next door. I'm next door, but yes, I'm looking for things to do.
Okay. I got some
Good to
things.
see you guys.
Yeah, let me know. Could do some trials next year.
All right, so that was Max stopping by the courtroom for Yak. We're actually going to switch up because look who's back. Our favorite is here, Judge Whitaker. I got to change the title. I got to change the headline. We got Judge Whitaker back. Man, I miss Judge Whitaker. I'm not going to lie. So let's go ahead and get Judge Whitaker up in here to see what she's talking about. Hold on a second. Boom. All right, let me rewind this real quick. And then we'll get into it. We should have a little bit of a delay, but y'all know Judge Whitaker, she's probably ready to get this thing going.
These niggas lacking.
I see y'all. Turn your mic on, Judge Whitaker. Oh my gosh. This is really low. Hold on, y'all.
If you look on our website, there are very clear instructions about how you're supposed to handle Rule 22. And you're not supposed to file it in the case, and you're not supposed to send it to Chambers. You're supposed to send it to our Public Information Office, and then they take it from there.
Thank you, Mama D.
But, I mean, I am aware of it, so just in the future, if you can try to do it the correct way.
Of course, I think my colleague filed that one, but.
Okay, well, yeah, you can blame it on your colleague, that's fine. But anyway, in terms of, I do not mind if you have.
The mics aren't right.
I don't even
Dang.
know if notice went to anybody or if anybody is gonna have any objection. That's one of the reasons why it needs to be done a particular way. So I don't have to find out when we have everybody here, but assuming no objection, you certainly may use your laptop. And if y'all have a still photographer ever, that's welcome. Any other kind of like feed can just go through the pooled camera. All right.
So is she going to make them end the live stream, or what is she saying?
So we'll just wait till we get everybody before we get started. Other than that, I'm gonna rearrange my.
So it looks like Law and Crime might not have a feed today. Yeah, shout out to Mama D. There's a lot going on this morning. So I don't know if Law and Crime just got kicked out of the courtroom. She said you can use your laptop. What does she mean by that? All right, it's a little confusing. So we might switch back and see if they're... So they're still not into... bond for Yak Gotti yet. But we can listen to some of this if y'all want to. Let's see.
Your case has been assigned to me just for bond purposes. The state may at some point indict you for what you were arrested for, and that'll be randomly assigned to some judge. It might come to me. Chances are it will go to a different judge. But as long as there is a question about bond in your case, then Mr. Tevis or Mr. Wolf, one of the lawyers working on your case, will bring that to me. So that's all we're working through today. Mr. Tevis, you are here on behalf of Mr. Wolf?
Yes, Judge.
Great, and we have Ms. Clark for the state. Mr. Tevis, I am ready to hear from you as to why Mr. Robinson Baker is a good candidate for bond and what that bond should look like.
Judge, you of all people are one of the are very well versed in the applicable case law that's going to be considered when establishing bond. But I would like to just go through 3 or 4 cases that have some pretty, I think, powerful language that is often forgotten in this building.
Also, before we keep going, it looks like that we're not going to be able to see Shannon's hearing today. Apparently, according to Thugger Daily, it looks like the request for media has been denied since it wasn't filed within 24 business hours, which is crazy. What? That's what I'm hearing from Thugger Daily. Let me see. And then he says, I think it won't be live streamed. The other 2 will, but will be uploaded after via Law and Crime. Okay. So we've got that one from Law and Crime. Let me double check and see what else I'm hearing, y'all. Remaining 5 defendants. All right, so let's keep going here.
That I want to argue against
so
the backdrop of that. So first of all, everybody's famous case in Georgia, Ayala, right? The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of that person in court for trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until and unless the state demonstrates guilt beyond a reasonable doubt. That is Vanderford versus Brand. In some limited circumstances, pretrial detention is permissible as a regulation serving a legitimate and sufficiently compelling government interest. And to that end, pretrial detention may be a permissible regulation rather than an impermissible punishment if it is rationally connected to a non-punitive purpose and is not excessive in relation to that purpose. And that is Carr v. State 303 Georgia 853 from 2018, which quotes United States versus Salerno. In our society, liberty is the norm, and detention prior to trial or without a trial is a carefully limited exception. And what that means is that the default position should be that a person is released prior to trial. That is the default position. We don't say this person has serious charges, they should stay in jail, because they haven't proven, the state has not proven those charges beyond a reasonable doubt. The defendant is always going to be at a disadvantage. We do not have the benefit of discovery. We don't have any of the information on which the accuser gave to the police that caused the warrant to be issued in this case. And so with that in mind, I suspect, as in the many hundreds, if not thousands of bond hearings I've done, the state will rely heavily on the facts because the bond factors are favorable to Mr. Baker. He's 27 years old. He was born and raised in Marietta, Georgia. He went to Sprayberry High School. He graduated from high school in 2015. He worked throughout high school. He worked at a Wendy's. He also did deliveries for his uncle's trucking company. He has continued to work doing that part-time upon graduation and also worked for FedEx making deliveries and working in their warehouse. He did that until he was involved in an auto accident as a passenger in a FedEx truck and was injured. He stopped working there. He then worked for AQC Traffic Control, which does construction projects where they, divert traffic and make sure that that's a safe environment. He has a history of employment here in Georgia. He has strong ties here in Georgia. His parents are here in the back, if you could stand up. And his mother, I think, was in the hallway. She may not have had her ID because the media case, they're not letting us in.
Right.
But his family is here. They're in constant contact with our office. If he's released on bond, Mr. Baker would reside with them in East Point. I don't have a GCIC, but I am aware that he has one prior incident involving, I believe, marijuana, and there was a firearm in the vehicle, not his, but I believe that he either has a charge or was sentenced in that case. I'm not aware of anything else that would show that he's a danger to the community or risk of committing further felonies. On paper and in reality, he is very tied to the community. There's no risk of fleeing here. There's nothing that would indicate that there's going to be intimidation of witnesses or anything like that. In fact, a preliminary hearing was conducted. We have a transcript of the audio of that I've reviewed, and it was the opposite. The alleged victim in this case called him repeatedly, I think 12 or 13 times, and demanded that he provide money to her, and threats were made to him, but nothing in the other direction came out at the preliminary hearing. I can go into the facts of that. I'd rather not, because true to my word, I want to say that bond hearings are not about the facts of the case, but if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now, assuming he has not done the thing that is on the calendar.
That's true.
So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than 50,000, Judge. I think, I believe that 25,000 would be appropriate. You know, I know your background, having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice is to set a high bond, which in all honesty is, you know, enriching the bonding company, but I don't think that that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bond?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do
and
that.
that's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in
Oh, whoa,
June,
look at my shirt.
and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March. And so.
And those for y'all just joining us, we're still waiting on Yak Gotti turn for his bond hearing. You can see his mother sitting back here. So we're just.
I think there was one that was
May. It's May.
I'm sorry, there's a delayed outcry.
That could be, but
Yeah.
the incident date was May
23rd or something like that.
May 3rd. And then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any
No one
insight
knows.
into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a gap in that. Obviously, it wasn't a situation where he's on the run or anything like that. I'm not sure if they were in discussions or talking to him, hey, we'd like you to come in and talk, and they were not effectuating the warrant because they were hoping that he would come in and speak with them.
Right.
But I don't have information that he was fleeing or anything like that.
Okay. All right.
Thank
you.
He said,
Ms. Clark.
two new polos.
Oh, Ms. Clark, before you go, you will come on. I have to tell you, good morning. I think Ms. Jackson, how are you doing?
Oh, I'm great. How are you, Your Honor?
I'm well. This was an add-on calendar that came out late yesterday, so I don't know if you had a chance to look up Mr. Robinson Baker's criminal history.
Yes, I do have it, Your Honor.
Great, if you'd share that, please.
Yes, sir. He has 4 cycles. The last arrest was August the 24th, 2021 in
And
Cobb
this is Miss
County
Jackson for
for
the state.
possession of marijuana with the intent to distribute and possession of a firearm during commission of a crime. He does appear to be on first offender probation in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have 1 prior misdemeanor conviction in 2022 in Cobb County for a non-fingerprintable offense. Nothing in addition, Your Honor.
Thank you so much. Officer Evans, I wasn't gonna be calling on you today, I didn't think, but do you know if there is a warrant in the system for Mr. Robinson Baker for his probation out of Cobb in light of
Right
this
Street,
situation?
relax.
Good morning,
Jeez.
Your Honor. Yes, Your Honor, there is an active
I can't hear
Cobb
you, it's
County
odd, you're not
probation
muted, but
warrant at this
can't hear
time.
you.
And Right Street was asking, where's Kayla? From the looks of it, it looks like Kayla is actually taking a back seat. As y'all saw, Max was in court here in in Judge McBurney's courtroom, just waiting to go in. And what we're hearing is it looks like Max is still taking the lead on Shannon's bond hearing. Because we just got something from Law and Crime. It says Max announces there is a plea deal in the remaining case against Shannon Stillwell or Shannon Jackson. And they're in Judge Belinda Edwards' courtroom right now. But there's going to be no live feed from Judge Belinda's courtroom, unfortunately. I'll keep y'all updated.
Your Honor? Can you hear me? Okay. Your Honor? Can you hear me, Your Honor?
Other people can hear you, that's peculiar. Some of my staff said they could hear you, but it's not coming into the courtroom. I don't know what that deal is.
Looks like they're having
He
Zoom
is on
issues.
active
Just want to type in
probation.
the chat, whether there's a warrant, I'll relay that.
And y'all saw Kayla was just sitting there.
He is on, yeah, he does have a warrant. Okay.
Is that Kayla sitting on the state side?
Is on
Well,
active
just want to type in
probation.
the chat, whether there's a warrant, I'll relay
There's
that.
Kayla right there, if y'all are wondering. They're going back and forth between courtrooms.
He is on, yeah, he does have a warrant. Okay,
Thank you, Gigi.
That's what I needed to know. Appreciate it. Ms. Clark.
Good morning, Your Honor.
Good
Boy,
morning.
today is a mess.
So to answer, I just wanted to start to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had, in speaking communication with the defendant, he was trying to give himself an opportunity to turn himself in. After a few months, the defendant did not turn himself in. So that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So
Now,
that
Mr.
is-
Tevis said something about Mr. Wolf getting Mr. Robinson Baker to turn himself in. Your understanding is contrary to that he was given an opportunity to do that, but that's not ultimately how it played out?
Yes, Your Honor. That's
Okay.
not, so in lieu of that, that is why that you have the delay in the arrest there.
Okay.
And Your Honor, counsel opposite refers to, he is correct. A person is innocent until proven guilty, but we're not here for that. We're here for bond. And to address that, we're looking at the
fair point.
Ayala factors. Your Honor,
why she
the
yelling?
state
Mic
wants to
is
bring
hot.
the first reason we feel that the defendant risk of flight. It seems that based on counsel opposite's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction.
Not great.
Have a past DUI conviction, as well as showing the fact that, bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge, felony charge, Cobb County Sheriff's Department. That is on cycle 2. That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I wanted to highlight that as well. Risk of committing felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, was 5 consecutive, so he is still on probation for that. Based on my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that that is likely because of this arrest. There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is. There's a young lady, Kim Yee, who actually was a friend of the victims at one point. She actually ended up coming over to the place where the incident location, where the assault happened. So these people know each other, and there is an intent to intimidate the witnesses. Ms. Head, the victim in this case, says she fears for her life, and that she does not wish for him to have bond. She is actually has provided a statement to our victim witness advocate that she'll read for us. But this is a serious capital felony crime, despite counsel opposite's suggestion. It is the nature of the crime.
Ooh, hold on. I think we might have Shannon. Oh, we've got Belinda in here. Judge Belinda Edwards is in the building.
So we're going to move to the final plea calendar, indictment 23 SC 186907.
Hold on a second.
Knox.
Judge, she is present today. I'll ask her some time just to go out.
Oh, we have so much going on today. Oh my gosh. So let me skip ahead here. Seems like Max is up here talking.
Positions
We're all over the place today, y'all.
Record is Max Chart. Is he present today? All right. In position 3, it lists Attorney Bumpus. Is that?
I should be the attorney of record of all 3.
I thought so, but I'm just. It was a misunderstanding.
And that's fine. And
looks like Max is taking the lead on this one.
Court making time for us, Your Honor. We will have a negotiated plea to present to the court this morning.
Hold on 1 second. I need to get the ADA on the record.
Good morning, Your Honor. Chris Sperry on behalf of the state of judicial efficiency. I'll handle all 3 matters.
All right. Thank you.
Let me see if I can.
And Your Honor, I do believe that I need to sign some indictments in preparation of the plea. Do we have those in court? Oh.
Yes.
Rice Street did not just call her grandma. Oh my God. Relax,
so you need
man.
a few minutes, we can do something else.
Yes, Your Honor.
All right, that's fine.
Thank you.
All right, here we go. Does
We will move to the all-purpose criminal calendar. Position number 1, indictment 22 SC 182298, Janice Dillard.
let me see if I can find this.
Position number 2, indictment 22 SC 182298, Russell Green.
Yeah, I'm glad Max is in here.
All right. Position number 3, indictment 22 SC 185220, Terry Relaford.
Good morning, Your Honor. Cameron Mackey on behalf of Mr. Relaford. He's present with us by way of Zoom.
And who's the ADA?
Judge Frank Marquez on behalf of the state. I'm filling in for Miss Washington today.
All right, Mr. Mackey, we're here.
And I'll keep an eye on the other live streams too, y'all. We're all over the place.
On this matter?
That's correct, Your Honor. We have received discovery. I've not yet received an
Mr. Clark.
But I understand Miss Washington is currently in trial, so we're going to circle back when she gets out of there. But this case is ready to be put forward to a final plea calendar.
All right, we're moving on to a final plea calendar. You'll be notified of the next court date.
Y'all are crazy.
And if there's nothing further, all parties are excused.
Thank you, Judge. Thank you, Judge.
Position number 4, indictment 23 XC 191-773, Jeremy Malone.
Good morning, Your Honor. Cameron Mackey on behalf of Mr. Malone. He's present with us, but he's in custody.
Position number 5 is also Mr. Malone. Indictment 24 SC 003090. Mr. Marquez, are you representing the state on both these matters?
I am, Your Honor.
All right, they're both on for case management.
Y'all gotta let me know. Is it are y'all going by Shannon Stillwell or Shannon Jackson? I keep hearing two different things. I think his legal name is Shannon Jackson. So used to call him Stillwell though. I think Max calls him Stillwell.
All right, good morning, Mr. Malone. We're here today for case management. Mr. Mackey, where are we on position 4? And then we can move to position 5.
On position 4, we have received discovery and an offer. That case is ready to go to a final plea calendar. And Your Honor, I believe that these are
right.
scheduled for final plea in
Shannon
January.
Bumpus.
Yes.
So we're expecting to do that on position number 4.
All right, position number 5 is indictment 24 SC 003090.
And Your Honor, for that case, we have received discovery this morning. There was an issue with an interview that wasn't playing nicely with the evidence.com, so the state has kindly provided me with a USB that contains that file this morning. This case is also on for final plea for January. I am going to review the interview, and if I have any additional motions, I'll file them by the end of the week.
All right, thank you. Anything from the state?
No, Your Honor, and we did extend an offer on both cases, Judge, just for the court's information.
All right, so we will look to see you all in January for final plea. If there's nothing further, all parties are excused.
Thank you, Judge.
Thank you, Judge.
Position number 6, indictment 24 SC 004656.
She's knocking them things out.
Kevin Mercado.
Judge Darrell's Mercado, he only speaks Spanish. I requested a Spanish interpreter. I sent Mr. McKeon an email about that. I don't see one yet.
All right, we'll have a seat. We'll come back to you.
And also, Judge, position 2, Russell Green, they've let people now in the courtroom. So he's present if you wanted to return to that one.
Position number 2?
Yes, Judge.
All right, position number 2, indictment 22 SC 182298, Russell Green. Mr. Marquez, are you representing the state?
I am, Your Honor. Just so the court is aware, the state is going to be submitting a null cross on positions 1 and 2. I thought we had already done that, but clearly not.
All right, Mr. Green, the state is announcing that they are no longer going to pursue this case against you, and they will be submitting a null process order for the court's consideration. Thank you for showing up this morning. If there's nothing further, you are excused. Position number 1 is indictment 21 SC 182298. Mr. Marquez, is that your announcement for that indictment as well?
That's correct, Judge. Just so the court remembers, this is the one where the third defendant, the other third co-defendant took responsibility for everything in the house.
All right, so that case is null process as well.
Thank you, Judge.
Position number 7, indictment 24 SC 004525, Xavier Rainier.
He's in custody, Your Honor.
Ms. Jones, is that your client?
Yes, Judge.
Mr. Marquez?
Yeah,
you
she's
represent
knocking
the
these
state?
things out.
I am, Your Honor.
All right, it's on the calendar for plea and arraignment, so you can bring out the defendant, please.
Judge, I also filed a motion for bond reduction on that one.
It's not listed on the calendar.
Because she put the calendar out before I filed it.
He has a,
She put these calendars out a long time ago. I filed it,
and Judge, I would, and with all due respect to Ms. Jones, I would ask to have that set on a calendar or a specific calendar so I can bring in the victim. The victim deserves to be here.
I filed it on November 20th. I sent copies of it to everybody.
Does that include Mr. Marquez?
Yes, of course it does.
You said everybody. I don't know who that includes.
Well,
Yeah,
it
Peyton
includes the
Sound, this has been
relevant part
happening.
is Mr.
It's all good.
Marquez.
All right, so
And the case
Mr.
manager.
Marquez,
We'll figure it out.
Ms. Jones is asserting to the court that she gave you a copy of her notice.
And if she electronically filed it, I don't doubt that at all. The only thing being, Judge, because it's set for a plea and arraignment, not necessarily a bond reduction, that's the only reason that I would ask for a particular date on that.
All right, so let's deal with plea and arraignment, and according to you, Ms. Jones, he already has a bond, correct?
He has a $10,000 bond, but the bond order reads $11,000. So yes, he does have a bond.
All right, as to indictment 24 SC 004525. We're here for plea and arraignment, Ms. Jones. What are we doing?
We'll waive formal arraignment under a plea of not guilty.
All right, so the court will enter a scheduling order. You will be notified of the next court date. Ms. Jones, I'm going to come back for the bond reduction and give Mr. Marquez an opportunity to reach out to the victim. So we're going to hear it today. We're just not going to hear it right now.
I hear it
So
today.
it seems like,
Okay,
Yes.
I understand. I was just clarifying, Judge.
so I think what's going to happen is Kayla's going to handle Yak's bond and Max is going to handle Shannon's plea. That's what it's looking like.
Let me say this as well. There is
Y'all hang in
a
there.
non-complex
Thank you
case
to everyone
that
who
should
liked
have
the video,
already
by the way.
been transferred to this courtroom. I'm not sure why they're dragging their heels. That case number is 23 SC 191544.
Non-complex does what it does. Delay, delay, delay.
Well, it was already delayed when I picked up this case, and I've been in communication with them for a while, and I can't figure out why they haven't submitted that. And I'm concerned about that one because that one is a criminal damage to property in the second degree. The discovery I see in the file from the non-complex attorney suggests that it's a misdemeanor at best, and he's been in custody for quite a long time. You've been in custody since May of 2023? That's 2024?
Yes.
He's been in custody since May 29th of 2024.
6 months later.
And then he did some time on that case last
On
year.
the 24 SC 004525 or on the 23 SC 191544?
He got picked up on the 24 case,
Get him right,
Judge.
Judge
Okay.
Edwards.
And then he's also being held on that 23 case.
They never set a bond in the 23 case?
He has a bond, and that's been reinstated.
All right, okay.
And Judge, just
GG,
so
you're
the
probably
court is
right.
aware, and there was an ex parte filed on the 23 case. So it was under judicial hold status for a little bit.
Right, and when I got the file, I met with my client, determined that that request had been made in error. It's been withdrawn, and so it's ready to come here. I'm not really sure what they're waiting for.
All right,
But there's been a lot of dragging their heels on that case.
You can look into that while we wait for Mr. Marquez to speak to the victim,
Okay.
or have someone in his
Come back
office
up.
speak to the victim.
Thanks.
All right, we're gonna take a pause. We are doing this, man. The back and forth continues. Oh my gosh. Who's gonna win? I'm gonna put a poll in the chat. which one of these cases will be done first? Good Lord.
And everybody, I'm just gonna give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
Yes, please use the mics.
C-183-572, State of Georgia versus Mr. Miles Farley. Mr. Farley, if you'll please raise your right hand.
Y'all might as well go ahead and let Miles Farley free.
Given the matters pending before this court will be the truth, the whole truth, nothing but the truth.
We've seen the evidence.
Okay, put your hand down.
We've seen the evidence, my guy.
I'll let you sign before I ask any more questions.
It wasn't him.
And Mr. Body, maybe reposition the mic while he's doing that.
Yes, Judge.
And this is the attorney that actually got arrested for
Mr. Farley,
having
did you state your true, correct, and
pills in the
legal name for the
courtroom.
record? Farley. And Mr. Farley, are you at this time taking or under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? And how far have you gone in school?
I got a bachelor's degree.
And are you able
Can you
to?
also speak into the mic, please?
26 and got a bachelor's degree.
And so are you able to read, write, and understand the English language?
Yes.
Right, here goes
You
the plea.
understand you are charged in indictment number 22 SC 183-572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm in the commission of a felony. You understand you're currently charged or indicted with those counts?
Yes.
I mean, do you understand that you have the right to plead that they're not guilty, guilty or not guilty to these charges, and if you pled not guilty, remain
Why is he
valid, you may
taking a
receive
plea
jury
deal?
trial. Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir?
Yes.
And are you satisfied with the services that your attorney has provided?
Yes.
And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case?
No.
And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment,
Why is he
including
taking a
any
plea?
with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to?
Yes.
And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years?
Yes.
And do you have any questions as it relates to that count, the single count that you'll be pleading guilty to?
No.
And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation
These niggas lacking.
as to the sentencing recommended for the count that you're pleading guilty to, so the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge.
Yes.
Do you have any questions about that?
No.
Come on, man.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
All right, well, let's see what he gets for count 1. But still,
Mr. Farley, do you understand that
If
this
Yak
plea may
got
be
off,
used to enhance
if
sentencing
Shannon
and
got
other
off,
convictions in this jurisdiction,
Miles
as well
Farley
as in
could
other
get off.
jurisdictions, including the federal courts?
Yes.
And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status
This is sad,
and will
man.
result in deportation, regardless of any advice given to you by your attorney or anyone else?
Yes.
Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir?
Yes.
Do you also understand that by pleading guilty, you're giving up or waiving the following rights? The right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, The right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case. The right to the presumption of innocence. The right to testify on your own behalf and to present other evidence. The right to subpoena witnesses and to compel the production of evidence. The right to have the charges proved against you beyond a reasonable doubt by the state of Georgia. And the right to appeal if convicted of these charges after trial. You understand by taking a guilty plea here today that you're waiving or giving up all of those rights? Yes. And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today? No.
Why? I don't get it.
And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that it is in your best interest to do so? Yes. And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts this plea of guilty, places you in the same position as if you were convicted after a jury trial? Yes. Okay. And how do you plead to count one, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC 183572? Guilty on the Alford. And Mr. Farley, is this Alford guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to? Yes. And do you understand that you may have a limited right to appeal this guilty plea conviction? Yes.
We looked at this indictment. All he did was pose in a picture for some videos, and then he was in the car right before Shamil Drinks got shot.
You also understand
So
you have
why
only
a
4
RICO
years from
charge?
today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea. Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he.
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time constraints that you have to file under those areas of the law. Yes. Okay. Do you have any questions about that? No. Okay.
All right, and your attorney, Mr. Menendez, will represent you until 30 days from now or the last day of this term of court, whichever is later. And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am. And just so the record's clear, I just provided to Ms. Percival the indictment, which was signed by all parties as it relates to the defendant's guilty plea to count one conspiracy to commit RICO. Your Honor, had this case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th of 2013 and May 8th.
Right, and so what we have ultimately is that there is no evidence, none.
That's what the state would have shown, Adam. Come on now. We already have one guy that you said committed this murder. Man, he's not guilty. He was found not guilty. What are y'all talking about?
2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL
Just Whitaker's asleep already.
Areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. Oh, The recommendation as it relates to, or the joint recommendation that the parties would make to the court, it's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to.
That's an Alford plea.
But it's also my understanding he qualifies for the first offender or treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either. And the recommendation will be 5 years to be served on probation.
Interesting.
All right. Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
All right. And have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
So he qualifies for first offender. That's
if
not
you
bad.
Successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon. Understand? All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Judge Whitaker said, you better behave yourself. And Jen said, I don't understand pleading guilty to RICO when the other defendants were found not guilty. Make it make sense. Well, now it makes sense. He gets to get out of jail. He qualifies for first offenders. So she gives him, let's say, this would be amazing. She gives him time served plus 2 years. Well, he's got to keep his nose clean for 2 years. And then he's not a felon anymore. Gets to get out of jail. Not bad. But he's not going to get time served plus 2 years. That's the issue we run into. Well, let's see what Judge Whitaker says.
Despite having a vast network of opportunity from his...
Let me rewind a little bit. And we'll get into Yak Gotti's hearing here shortly.
And taking things this far, Your Honor, putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alford is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime.
Judge Whitaker saying, like, listen, I've seen this movie 4 times already. You sure you don't want to wait a minute and just get a not guilty like Yak and Shannon did? Stay on house arrest. Be good. Come to court. Yeah, if you don't want to run that risk, like I said in the chat, I get it. Just take this, keep your nose clean for however many years that Judge Whitaker is going to give him. And then you got a first offenders, no felony. It goes away.
Understand that, right?
The legal system's amazing.
All right, I find there to be a factual basis for this plea. I will accept it under Alford, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before,
not bad.
How you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
I can't imagine.
Have any real special conditions, obviously, other than follow the law.
Okay.
He's a first offender.
All right. Well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No, ma'am.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up, and that you are following the law. All right, good luck to you. Thank you.
Hey, shout out to Mr. Farley. Not a bad deal. He keep his nose clean, do what he's got to do. He'll be up out of there. Rice Street's not feeling it. Rice Street wanted another victim. That's all right, Rice Street. 5 years probation. Alford plea. He just pled guilty to RICO. He qualifies for first offenders, so if he does what he needs to do, this goes away. I'm not mad at it. Let's switch over now. I mean, we are everywhere all at one time. Let me change this headline and let's see what Kayla is talking about over here at Yak Gotti's bond hearing. And we'll get to the rest of the defendants here in a second. All right, let me see. All right, here we go. And thank you all for the super chat. Shout out to Dr. EJ at $50 to chat. You guys show some support and like the video and send some super chats. ClassE puts in a lot of hours for us. I appreciate you, man. Happy holidays.
All right, so do we
Thank you.
need to take a break so you can move people up and down, or do we have other people up you can handle? Okay, we'll do that.
There he is. There's our guy. There's a guy in here. What a crazy morning. We got 3 different questions we're trying to follow.
Thank you. Mr. Rao, are you handling this or do we need Mr. Abate back? You're handling, okay.
Yeah, because Mr. Abadi's in.
Let's get one thing up here on the screen.
We're up here running around like crazy. Imagine these attorneys, what they're doing. Y'all see Max running through this courtroom, Kayla running through the courtroom, Adam was in this courtroom, ran back to the other one. What a mess. And I think the sound should be good on this. So let's do this. Y'all let me know how the sound is.
All right. Ms. Rivers, are you ready? Yes. Okay, this is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick. I'm all right. How are you doing? I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your two cases. You've got one case that's assigned to me in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these two cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these two cases and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me.
All right, Kayla is back.
You ready?
Last time we saw her at the podium, she was taking some shots at Ms. Hilton.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to be given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're gonna get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom, or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly, because he was in 1C.
Yes, Judge.
But in 2B, 1 floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery.
And I know that, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are going to work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working for, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail.
Talk to him, Caleb.
I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these two cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and they'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that
I wonder if he's talking about his mom. It kind of sounds like he's talking about mama. Who is he? Who is Judge McBurney referring to and keeping things the same? Because we know his mother does not have a completely clean record, from what I understand. Who is he talking about here? Those people.
We need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place. And the next day there's a dead guy in the parking lot. And that has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides so that he can, you know, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of maybe
Shannon's
that bond's
wife.
not appropriate, but I wanted you to know
crazy.
that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation and then I'll get the warrant out to everyone.
Yes, Judge.
Oh,
These niggas lacking.
he's got a warrant. Oh no. Look at Kayla. You can see her right here. She looked at him. Oh man. She looked at him. She said, what the hell? Maybe she knew this already though. Here we go.
The defendant stands before you, having been indicted on
She's talking to
2
him right
separate
now.
cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all,
maybe she didn't,
they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there
the entire time. And by he, I mean the victim. The victim
Okay.
remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Jeez.
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Hansberry.
Honor.
All right, somehow that device's volume got turned down, but we're back. All right, so your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault, I'm gonna call it the assault case.
That's correct. And in addition to that, the sheriff's office had an opportunity to speak with Mr. Kendrick. And essentially there's a lot of commotion in the background because it's on a body camera footage, but they were able to secure a statement from Mr.
Rice
Kendrick.
Street's calling cap.
Mr. Kendrick or from Mr. Wimberly?
Both, but
Okay.
with respect to Mr. Kendrick, it's essentially saying, what else am I gonna do? It's about respect. They're stealing my stuff. I gotta do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and then the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does in fact have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015.
Yeah, Rice Street said, "What? So he was the victim of theft?" Yes, but he's saying, but what they're saying is they have Yak Gotti saying, "Oh, I'm in here. I can't just let these dudes steal my stuff. It's about respect." And then he did what he had to do.
The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC.
Dang.
For which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that?
Yeah, and this is tough. He's basically building the case saying he's had a past of retaliation. Somebody stole his stuff. He retaliated, therefore deny bond because he's a danger to society. Yeah, dang.
That case number again, please.
Yes, Your Honor. 15 SC 140116, and it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentence, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, just Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that
that's a good
your
point.
office has filtered through that and we've got the two cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations. Or it would be something in aggravation at a bond hearing or at a sentencing hearing.
That's
is your
correct.
best forecast, with maybe one exception.
That's correct.
Okay, all right.
Thank you, Judge.
Thank you. Ms. Bumpus, want to give you the last word.
All right, here we go.
I'm gonna not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is far for Mr. Kendrick, everything's all connected. And so there may be, it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimberly. And you know that's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense. until that warrant is addressed. You know
That
full well,
sucks.
once that warrant is addressed, or if it's lifted, or it's dismissed, or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the 2 cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those 2, the federal case and the state case, are one occurrence.
I got it.
And that
Dang, that's
the
tough.
additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015,
right? Because
it would be that state probation.
That sucks, man.
Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure. Good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't. And we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna, can someone email me about the probation?
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state? Yeah. All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you for being here.
Well, yeah, this is all a mess. So no probation for Yak. Or probation. I said no probation. No bond for Yak right now.
All right.
Which is interesting. So basically the judge said we're going to have to table it until we get this warrant situation figured out. So I don't know where he's going to be kept or what's going to happen to him while they figure this out, which is crazy. So I can't imagine there'll be anything today. It looks like the family's all filing out. So let's go ahead and see what's going on with SB up in here. We're finally back at it. We're hopping courtroom to courtroom. That stinks for Yak, man. I know he was hoping and his family was hoping he could get home by Christmas, but I don't know if that's going to be the case. Unless they can somehow get this figured out in the next what? Because they're not going to be in court all next week. Unless they can get it figured out in the next 2-3 business days. That's it.
Good morning, Mr. Jackson.
Here we go.
As you stand before me today, you are here on 3 indictments. Indictment 22 SC 181814, Indictment 22 SC 185532, Indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson. SHANNON JACKSON.
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
Here we go.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand
Come on, man.
English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by a convicted felon?
Yes, sir.
Do you understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement?
Yes, sir.
Do you understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement?
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
You understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, but less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance, is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by an inmate. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by an inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, the plea of guilty, acknowledgement, waiver of rights.
Yes, sir.
I remember. All right. And did you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Sharp, are you waiving any potential defects in this indictment on behalf of your client, as well as formal reading of the indictment?
So waived to both.
And Mr. Jackson, do you need any more time with Mr. Sharp? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea...
And for everyone that's confused, these are these took place before the YSL trial. These weren't involved in the trial. So these are things that happen outside of the YSL trial.
Also can be used in the future. It's what we call recidivist.
Is there a separate
which means
issue?
That if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there could be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And do you understand this is a negotiated plea of guilty?
Yes, sir.
Which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes,
Get
sir.
this man out,
Now, you
man.
also
Let him go.
understand that if you were under probation or parole,
Let
this
that be
can have a
rain out the
negative
top of the.
impact under probation or parole status. And to be clear, this would not have a negative impact on the offense for which you just were sentenced, as all of these offenses occurred prior to entering this plea. Do you understand that?
Yes, sir.
Now, do you also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also would include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are a convicted felon.
Yes, sir.
Now, do you also understand that there can be, let me get there. Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. And at the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case.
Come on,
right to the
man.
presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alford v. North Carolina, okay?
Yes, sir.
So I'm going to go over each of these indictments specifically as to the counts. Do you understand Alford v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number 23 SC 188183. Do you understand you'd be entering a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2?
Yes, sir.
Do you understand you'd also be entering a plea on Alford v. North Carolina in counts 3 through 8, which is the possession of methamphetamine,
Another Alford plea.
and the possession of prohibited items by intent?
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested, and the state is not objecting, to an Alford plea as to the count 2, possession of a firearm during commission of a felony, and count 3, possession of a firearm by a convicted felon.
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you know me, I'm annoying. By taking failure to maintain insurance.
Yes, sir.
Now, Mr. Sharp,
Morning, gang.
understanding that you negotiated these with other attorneys and I'm sort of standing in place, could I fairly accurately summarize the counts for which are the no contest as well as the offer?
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
All right, and could that be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony?
You got it,
by
yeah.
taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alford v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict? Or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute. And then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the F.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you
Now let him go
understand
home.
You would have only a limited right to appeal this guilty plea conviction.
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you wanted to challenge the constitutionality of this plea.
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? Do you understand that you would have up to 12 months from today's date to also file the habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which
All right,
is
here we
the
go.
22 SC
Factual acknowledgements. Give me 1 second, y'all.
5532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and positively tested, positively alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle. Judge, in addition to locating promethazine, which was a Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. Judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine.
Oh, Lord.
Would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony is 5 years
10 years
probated
3
to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served.
Are you serious?
Judge, as to count,
Come on.
as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 was going to be 10 to serve 3 commuted to time served balance on probation, as opposed to 10 years probation.
I will defer to you as you were the one actively involved in negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for 22 SC 1.
This is the recommendations from the state.
Count 1.
That's what we're going through. Thank you, Henry.
Possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3, commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, to a statute minimum of 1.
Okay.
So if we're going to get there, may I make
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3, commuted to time served, balance probated, and count.
Don't get arrested out here.
5 years probation consecutive. Correct. The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3, 10 to serve 3, commuted to time served, balance on probation. Count 2, 5 years probation, consecutive to count 3.
Yes, Your Honor.
Yes, Your Honor.
And count 1, 3 years to serve, commuted to time served.
Correct, Your Honor.
Yes, Your Honor.
You may continue.
And as to case number 23 SC 188-183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation.
They're really necessary.
There would be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies nor any residence. Quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is
he's about to go to Houston.
Case that was assigned to my unit, and I believe it actually was initially with the high-profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist, this is irrelevant, frankly, whether or not we would be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of the larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis,
no, I guess he's not coming back.
Case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there was other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I've been provided with that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. but I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I wanted to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
Man, where's this guy
All right,
during the
thank
RICO
you.
trial?
So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he has to maintain gainful employment while on probation. There is to be no contact or communication, directly or indirectly, with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept him as a probationer, correct?
That's correct.
All right. Anything else?
Nothing from the state at this time, Your Honor.
All right.
Here we go.
Anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court, supporting him.
Oh, his wife. Look at him.
4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to
He says
realize
she's there.
how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is, Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future there'll be a need to return back to Atlanta. I'm not trying to violate any agreements.
I agree,
have with
Amy.
the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that that would probably be the best workaround at this time, and quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I'm Ms. Jones, Officer Jones with Probation PCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the seat. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to the probation until Thursday.
All right, thank you.
Yes, thank you to everyone who liked the
What
video.
she's saying is until the state that you are moving to accept your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay? All right, as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right? So we're going to start with (22 SC 185532).
Let him go. Let that man go.
Negotiated and recommended sentence is on count 1. The defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served.
So that one's gone.
Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served.
Nice.
Balance on probation to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So
Related to the
people who
attorney.
used to be your friends or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And
Get him right.
from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail. And unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life if someone wants to give you
Not
an
necessarily,
opportunity,
but I get what
can
you're saying.
Step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process. and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems. Because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years. And nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state. And
So
your
he's only got to
attorney
stay
can
out of
work
Atlanta
what
for
those
5 years.
occasions
Nice.
are. But you cannot come back unless you have been approved to do so, and notice has been given to the state, and they've signed off on it.
Nice.
You are not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity.
Obviously.
I assume that you know all of the co-defendants in 22 SC 183572, so you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there, so there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with.
Mm-hmm.
So, did I miss anything?
Your Honor, just one thing. If we could put on the sentencing sheet that all these sentences are run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want
Yep, stay out the streets.
you and the court where I'm going to tell Mr. Jackson I can talk to him.
Yes, just put it all on the record about.
That's his
reporting.
probation officer.
Report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So, don't be late, don't miss that appointment, because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right,
Max looked at
so
Kayla.
At this time, is there anything else from either party?
Judge, just Mr. Sharp had recommended, I have no intention of leaving my office anytime soon, at least voluntarily, so Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exceptions that are necessary. That's great.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right. If there's nothing further, then all parties are excused.
Thank you, Your Honor.
There it is, man. Congratulations. SB in there looking at his family. Should we play?
Position 7 on the final plea calendar.
Look at SB.
Hold on. Excuse me. Position 1 on the final plea calendar.
All right,
Yeah, that's right, Right Street.
position number 1, indictment 23 SC 186.
Look at him walking up there.
Marquisha Knox.
All right, there it is, man. Shout out to
Knox needed to feed the meat.
SB. He going home, man. About to enjoy Christmas with the family, his new wife. And as Amy said, he's going to eat everything on that list. Y'all go stream Lizard Walk, man. That song is fire. I don't care. I love that song. He going home. He's going home. Now, let's see. Let's go back to Judge Whitaker. We might check out what's going on with Judge Whitaker for a minute. Or actually, I don't know. What are y'all saying? Let me see what y'all are saying in the comments, because I've been neglecting the comments for a minute because we were jumping back and forth to courtrooms, but this is a great deal. And let me see what they say. They're saying, so he got time served on everything. He's going home, and there was something else. Let's see. It's basically, it's looking like it's 12 years probation. And obviously he can't come to Atlanta for the next 5 years, I think she said. And that's our first time getting to see Belinda Edwards in there too. I think she was in there smooth with it. Shout out to Belinda Edwards. I said, Kayla better make sure her man is on the straight and narrow. I think he'll be okay. Run that Yak Gotti. Shout out to Yak, but yeah. Mr. Bumpless. He said Mr. Bumpless finally get to go home. Oh my God. Don't do that. Who started that Mr. Bumpus thing? That's despicable. Amy, thank you for the super chat. Amy dropped a super sticker with the cake. Oh my goodness. Is it that time already? Let me see. I missed a couple other super chats too. I need to say Nicole Brewer became a new member. Welcome to the membership side. My guy, Henry Resilience, in here with the 5 bombs. What does he say? Shannon has been given a second chance. Max was worth every penny. We need to hit 100K for the new year. Shannon deserved and earned his freedom. Yeah, shout out to SB. Glad they got him out of there, man. He shouldn't have been in there in the first place. We got Mama D up in here. Said, Classy Beats, we appreciate you. I appreciate y'all showing the love. Let's go ahead. I'm going to jump over and see what's going on with Judge Whitaker. I object. We have a new judge. Forget Judge Whitaker. Hey, what's the judge's name? That is Belinda Edwards out there doing her thing. Mr. Brown also says, what's the judge's name? Hey, Mr. Brown.
Yeah, that brother's starving.
Relax, man. Hey, you know what? I'm not gonna block your blessing. That is Belinda Edwards. She actually does have a YouTube channel, but she hasn't put anything on there in several years. So y'all give it up to the honorable Judge Belinda Edwards in here doing a great job. Yeah, I don't know why anybody would. I'm not gonna say anything. Yeah, hopefully Yak can get out of there soon. And it's really frustrating that he was so close to getting there. Now they have to figure out this situation with what's going on with that federal case. So I don't know. We'll just have to wait and see. Hopefully it'll happen soon. Maybe Kayla can put in some work. She is the bond queen, according to Woody. So she's got a few more days before court's not going to be back probably until the new year. I don't know. We'll have to wait and see. What else are y'all saying? Judge Edwards acting like Shannon's auntie. Yeah, as she rightfully should. Kyrese is in here, says happy Tuesday. Good to see you, Kyrese. Yak should have remained with Doug. No, I think Kayla, she did the best that she could. She tried to make it happen. Elijah Watts says, don't they have something in Georgia where if you do 3 years with no issues, they shorten the probation time? They have a first offenders program, but Shannon's not a first offender. So he doesn't get that. Miles Farley did get it though. And he's on the first offenders program. So as long as he keeps his nose clean, he should be good to go. Should be good to go there. Thank you for Amy reminding y'all like the video. 1,500 of y'all in here and 1,300 of you like the video. Oh my gosh. Amazing, man. Thank y'all so much. I think what I'm going to do is, let me see what Judge Whitaker is saying on this. I don't know if she got to the other defendants. This might be something that we review tomorrow. Let me double check and see. Yeah, because it's looking like she got through those pretty quick. Rice Street says, we was waiting to hear that Yak Gotti. Nope. Amy says, Kayla about to be working overtime, but I won't be on Yak's but it won't be on Yak's case. Oh my gosh. Oh yeah, I'm sure Kayla's happy too. And congratulations again to the new couple. Let me see. Run that Yak Gotti Rice Street. If you don't get out of here, man. Henry Resilient say Shannon's about to have another baby. Oh my goodness. Zahir says, more importantly, they don't want to send them back to jail because clearly, as the ward of the state, they've proven that they can't protect him, which makes them clearly liable for a lawsuit. And he's already suing them. If y'all missed that, you can go watch the live stream or the video where I covered the entire lawsuit. And we actually need to cover the Davion Blake lawsuit, or his part of the lawsuit. We're going to get into that at some time in this week. Anyway, thank y'all again for supporting. Thank y'all for being here, liking the video. If y'all could like the video on your way out, we're going to drop a couple more clips this afternoon. So make sure you stick around for that. Subscribe, hit the notification bell so you don't miss any time we go live or drop a new video. We'll be back here live tomorrow at 9:30 a.m. Eastern Standard Time. I don't know if court will be in session tomorrow, but I'll keep you guys updated on what's going on. And as always, hope y'all have a great afternoon. Keep growing, keep pushing, keep it classy. We out of here. Peace. Let that bit rain at the top of the globe.
Your shots and I'm on to my ups. Let that big rain at the top of the drop. Listen, walk your block, let that glizzy rock. Collect your top, they gon' chew you up. Shit, my ops right, I got money on my mind. And I can't deny it, beating all of my fucking items. And I gon' start a ride, by my name, they gon' slide. Bitches life size, bitch you like you bite size.